Hello friends, I'm Professor Kiran Patil. Welcomes you in our YouTube channel sharing the knowledge of agriculture. We have started this channel for spreading the conceptual and descriptive knowledge of agriculture. So friends, it is requested you please like, share and subscribe my YouTube channel and give useful suggestions. Thank you. So friends, today we'll discuss on a very important topic, intellectual property rights, patenting and plant breeders' right. Let's start the video. First, we see property. It means wealth or valuable things earned or owned by a person, like land, building, gold, etc. Property basically have three types. Immovable properties means property cannot be moved from one place to another, but the ownership can be transferred. Example land, building, etc. Next is a movable property like animals, farm machines, gold, etc. Third, an important type is intellectual property. It is a product, process, or idea that can be an outcome of human intellect and can be used on a commercial scale. The intellectual property, that is IP, it refers to creation of mind such as inventions, literary and artistic work, design and symbols, name and images can be used on a commercial scale. When a person get economically benefited from his idea or invention, so it means its intellect work on his property. What is IPR or intellectual property rights? It is the right on the intangible property that is an outcome of human intellect is known as IPR. Intangible means the property which is not physically seen. It is a legal right given to a person or inventor to become economically benefited from his invention and restrict others to use, multiply, or sell that product or idea. The forms of IPR are primary rights and sui generis rights. The primary rights includes copyrights, patents, trademarks, industrial designs, utility models, GI, that is geographical indices, trade secrets, related rights, trade names, and domain names. Whereas sui generis rights includes database rights, mass work, PBR, that is plant breeders' right, farmers' right, moral rights, and supplementary protection certificate. Now we'll see one by one in detail. In primary rights, first one is the copyrights. Documents which grants exclusive rights to author to publish and sell literary or musical or artistic work. It provides protection to books, movies, music, paintings, software, etc. The next one is the patents. Patent is a documents granting an inventor to sole rights to his invention for production and marketing of his product, process, or invention to derive benefits. A patent is an exclusive rights granted for an invention. Generally speaking, a patent provides an patent owner with the right to decide how or whether the invention can be used by the others. Here, it is granted for a limited period. The patent is also prevents others from copying the invention. Next primary right is trademark. Most of the time we seen the trademark on a product. Trademark is distinctive sign used by an individual business organization or legal entity to uniquely identify the source of his product to consumer and to distinguish his product from the others. The trademark may be designated by the following symbols. First is a TM, that is used for unregistered trademark. Next is R, used for a product or service that has been registered and legally protected. The SM sign, used for service mark that has not yet been registered. The C, used for notify the ownership of non-audio works, and the P for notify the copyrights of audio works. The next primary right is industrial design. These are the ornamental or aesthetic products of an article produced by an industry or a handicraft. Next is a utility models. It is similar to patent. They are also referred as a PT patent, small patent, PT inventions, or PT innovations. They are similar to those granted by patents, has a shorter term, more suited to a incremental inventions. The next and important primary right is GI, that is geographical index. The name of a region, a specific place, or in exceptional cases, a country used to describe an agricultural, natural, or manufactured goods or products or foodstuff. Geographical index refers to sign used on a product which corresponds to specific geographical location or origin. Most commonly, the geographical indications include the name of the place of origin of the goods. For example, Banarsi saris, Dashari aam, Nagpur santra, Nasik grapes. For example, Darjeeling tea is the first product which got the GI tag in India in 2004 and 5. Till now, around 365 products have been added to the GI list. Recently, the Kashmir saffron and black rice of Manipur got the GI tag. The next one is trade secrets. The trade secrets are anything, a formula, process, method, mechanism, tool, pattern, or device which the disclosing party, that is inventor, desire to keep a secret. The trade secret has no specific period. It may continue lifelong. No need to registration, not applicable to books, equipments, plant varieties, designs openly used. Next primary rights are related rights. It is similar to author's right, but which are not related to actual author of work. Next is the trade names. The name under which business trades for commercial purpose. Although it is registered name may be another. If we see an example, the registered as a trademark or a regular as a brand. For example, 2,4-D, that is 2,4-dichlorophenoxyacetic acid. A single chemical may have variety of trade names depending upon the number of manufacturers or number of companies. Like it is also known as a Weeder, Weedmaster, Amazon, etc. But the main ingredient is 2,4-D. Next one is domain names. The unique name that identifies the internet site. So domain name is commonly used for the internet sites. For example, www.google.com or www.yahoo.com. After primary rights, the next type is sui generis rights. They are the rights which are granted to the owners of small class of work having its uniqueness. The first type of sui generis right is database right. The rights which IPR grants to the computer database. These are provided by the European Union laws 1996 and the duration is 15 years but can be extended. The protection provided in database rights to substantial part of the database and the information is protected, not expressions. The next type is mask work rights. It protects for 2D or 3D layouts of IC, that is integrated circuits. And the duration for mask work right is 2 years for unregistered and 10 years for registered work. The third type under sui generis rights are PBR or PVR, that is plant breeders right or plant variety rights. It is important for the agriculture point of view or for the plant breeders. The IPR grants to breeder of new variety of plant. It can be granted to novel varieties which meets the DUS, that is distinctiveness, uniformity and stability standards. PBR also provided to breeder or his successor. Next is farmer's right. It is also important for the agriculture point of view or for the farmers. The farmer's rights are the legal rights granted to farmer to save, sow, use, replant, exchange, share or sell his farm produce including seeds of variety protected under the Plant Variety Protection Act, especially in the centers of origin of or diversity of plant genetic and animal genetic resources for their protection. Next is moral rights. The moral rights are the special extensions to copyrights that gives the originator a copyrighted work rights over its use. They can specify the moral conditions on further use exploitations of their creation even when they are sold or licensed to the others. The moral rights provided in Berne Conventions 1989. The moral rights provides right to attribute and rights to integrity. Moral rights cannot be transferred. The owner can object any contamination to his convention which will prejudice to his reputation. Next type is SPC, that is Supplementary Protection Certificate. It is a right given to medicinal and plant protection products. It is extension to patent for long-term authorization of patent for marketing. It comes in force after expiry of patents. If we see the duration, it is 5 years when granted, 10 years after filling the date of patent, and less than 5 years when granted after 5 years after filling the date of patent. The next and important type is indigenous property rights. It covers mature, long-standing traditions or practices of certain regional, indigenous or local communities. The knowledge about plant, animals, treatments of diseases by traditional practices. The indigenous property rights is the right for combination of tradition and non-traditional knowledge will form a rich and distinctive understanding of world and life. Hence, the protection is very necessary, otherwise it will be lost gradually. So friends, this is all about today's topic, intellectual property rights, patenting and plant breeders' right. Hope you like the video. Your all suggestions are invited so we can make more and more knowledgeful videos for you all. Please don't forget to like and share the videos and subscribe my YouTube channel. Thank you very much.